Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here to take your U.S. immigration related questions. So go ahead, put your questions in the comments now. I may answer your questions. You can put your questions in the comments both on YouTube and on TikTok. And as your questions come in, I will respond to those. Now, remember, the information that I'm giving tonight is general information. It is not personal legal advice. So if you are facing a situation yourself, definitely go ahead and schedule a consultation. But hopefully the information tonight will be very helpful. So tonight I'm going to be talking about the scenario where your spouse may have filed for divorce during your 2-year green card renewal process, and you're trying to figure out how you should approach this. This is one of those situations where it complicates your process, but there is a solution. It's very important that you hop on getting this resolved as soon as possible. Now, first, let me explain what I mean by this 2-year green card renewal process. When you are getting your permanent residence through a green card, through a U.S. citizen or green card holder, if at the time you're approved for permanent residence, you have been married for less than 2 years, you will get a conditional permanent residence. That is a 2-year temporary green card. And so within 2 years, you'll have to renew it. But in order to have it renewed, you have to make sure to jointly file with your spouse and then prove again after the 2 years that you continue to have a bona fide marriage with your spouse. That means that they want to make sure that it is real. Now, very important for you to timely file for this, and then make sure that you understand. I'm sorry, I just got disconnected. So it's very important that you timely file for this, or you will be denied. So you will be denied if you don't timely file and you don't apply with your spouse. However, if it's now if you are, it's outside of your control to apply for this, then you will have to apply for a waiver. So when I say it's outside of your control, it's an exact situation like your spouse, your U.S. citizen or legal permanent resident spouse, then files for divorce, or you become separated, or they're living with you, but they're refusing to go ahead and apply with you because they're maybe they're not treating you well. Maybe they're being manipulative. Maybe they're being vindictive. And so they're even though they're living with you as a spouse, they are determined that they're not going to help you to renew your 2-year to the 10-year green card. That's the situation that I want to talk to you about tonight. I want to let you know that there is a solution here. Let me remind you that I'm also here to answer your questions. So go ahead and put your questions in the comments, and then I will gladly answer those questions as I'm going through this topic. Your question does not have to be related to the particular topic that I'm talking about. And you can just simply put your question in the comments and I will answer. Now, to continue, let's talk about this, right? So I want to talk about the situation where you've already filed your 2-year permanent residence with your spouse. Your spouse went ahead, they signed the paperwork, and then you thought you were going through smooth sailings with your spouse until things just were not right. Your spouse, maybe out of the blue, I've seen this multiple times, out of the blue, they go ahead and they file for divorce. And I'm pretty sure at that point, your whole future in the United States flashes before your eyes. Because once your spouse files for divorce, then it is going to definitely compromise your your 2-year to 10-year permanent residence process, unless you submit this waiver request. So it's at this point, you can submit this waiver request anytime before, during the period of time that you can apply, or after you've applied. And this waiver request basically is a request based on evidence that you submit, asking the USCIS to allow you to apply for your own permanent residence. And there are going to be 3 permissible ways that you can get this waiver. One is based on a divorce. So when you're filing for this waiver, you will have to show that you have finalized your divorce. And even though you got divorced throughout the period that you were married, you did intend to have a bona fide marriage. It just didn't work out. And that's going to be still showing evidence that it was a real marriage. Within the last year or within the time period that you were married after you got the permanent residence, you'll have to show, for example, you filed taxes together. Maybe you shared a home, you bought a home, maybe you shared a lease, you owned a bank account together, maybe you owned other types of property. Maybe the both of you were on your children's school records. During your divorce proceedings, did you divide up your property because you shared that property, and so the judge had to go ahead and make sure that they ordered division of the property. Did you share insurance with your spouse? These are going to still be very important in this process, even as you apply for this waiver. As a matter of fact, whether or not you're approved for this waiver to apply on your own is going to come down to whether you submit great evidence to show that your marriage was real. So that's divorce. This bona fide marriage evidence is also required where you're applying based on mistreatment by this spouse. So if they file for divorce, you'll definitely get a request for evidence. Once you've submitted documentation, you'll get a request for evidence from the USCIS to show your final divorce decree. But you can also, on top of that, apply for a waiver based on mistreatment. So the mistreatment in this case could be verbal, emotional, it could be financial, and also physical. If you have endured this type of abuse, then this is also a way for you to obtain this waiver approval where you get to apply on your own. This is confidential, so they don't share this information with your spouse. Now with this, you have to show that you had a bona fide marriage. You still not, and in addition to that, you do have to show that you experienced this form of mistreatment or abuse or extreme cruelty. And it's going to be based on credible evidence. That means any believable evidence. If, for example, you have text messages, you have pictures, you have witness statements, you have a psychological evaluation showing that the emotional harm that was done to you, as well as other types of evidence of abuse, such as police reports or pictures or restraining order. These can be good evidence to show that, yes, you were mistreated and you do deserve to apply on your own. Now, in addition to that, you still do have to apply for, you do have to go ahead and apply to and show that your marriage was real. So even with the abuse that happened, mistreatment, you entered the marriage with every intention of being together. So that is mistreatment. The last is extreme hardship. So extreme hardship does not necessarily, you have to show that if you lose your status, you will face more hardship than the average individual who would lose their status. And with this, it doesn't require you to show that your marriage is bona fide. It doesn't have to, you don't have to show whether you're still with your spouse or not. But then remember that you have to meet a higher standard in proving that you'll experience extreme hardship, and it will have to be more than the ordinary hardship. So for example, if you say if you lose your status, you'll have to go back to your home country where you've given up everything. That while that is definitely a form of extreme hardship, the question is what would make it more of a hardship than the usual for someone in a similar situation like yours. Now, let me remind you that I'm here to answer your US immigration related questions. I'm both on YouTube and I'm on TikTok. So put your questions in the comments. I will answer your questions. Now, I am talking about going from the 2-year to the 10-year permanent residence and ways that you can go ahead and apply on your own if your spouse has filed for divorce, or even if they haven't filed for divorce, if they're mistreating you, or if they're just refusing to apply with you and you want to go ahead and apply on your own because that is the best situation for you. I'm explaining here ways that this can be done. Now, go ahead, put those questions in the comments. Now, when you apply for this waiver, you can apply for it anytime. So if your spouse 1 year into the marriage, you get a divorce, if at that point you choose to apply to remove the conditions on your 2-year to get the 10-year, then you can apply for this waiver at that point. You don't have to wait and you don't have to have your spouse's signature on the application. You could file it since you know that your spouse is no longer available to apply with you and you are divorced. You could file it, sign it on your own, and submit the relevant evidence. This is what I do to assist my clients. I help my clients to get this straightened out and to continue to get their 10-year after having the 2-year. Now, once you have determined that it's time to apply for a waiver, this can be after your application is submitted as well. So say your spouse went ahead and signed the documentation, and then you submitted it, everything seemed well, and then afterwards they filed for divorce. At that point, it's not too late. You can then still apply for a waiver to apply on your own. Even if right before your final interview comes, you are scheduled for an interview and you have not applied for the waiver, even at that point, you can then let the officer know. At that point, I highly encourage you get an attorney though. Definitely get an attorney to assist with this, and this is what I help my clients do. But even up until the interview, there is a way to request this waiver. So I don't see any questions coming in, and I'm pretty much finished with the topic that I came to talk about. So that will be it for me tonight. I'm hopping on over to Instagram in a minute where I'll continue this conversation. So go ahead, you can join me on Instagram. That's where most of my content is, and also on YouTube. Go to The Immigration Attorney on Instagram in a minute. I will be over there. Otherwise, you can go to the link in my profile to schedule for your consultation. Have a great night.